This is Hamptons versus Jasmine Weatherby, 2502045 LT. Mr. Smith?
Good morning, Your Honor. Andrew Smith, Keith 64541 of 39 Hampton.
Mr. Sandweiss?
Good morning, Your Honor. May it please this honorable court, Steve Sandweiss. I'm here on behalf of the defendant, Jasmine Weatherby.
Okay, and is the manager here?
The judge is already raising eyebrows. No manager present despite the financial dispute. That's strike one for the landlord's side. Would you show up to court without your key witness? Comment below if you think this was a strategic move or just poor planning.
There seems to be a dispute as to what was paid, and I asked that the manager from Hamptons be present.
I did talk with her this morning. We did get a copy of court, and there was a $15 discrepancy on one late fee where we were $15 over.
I get it. That's fine. I understand. We all make mistakes. But it's still, they're claiming they paid everything, it looks like. Right, Mr.
No, Judge, here's the situation. There's a couple. Number one,
I want to slow down.
Oh, I'm sorry.
You are contending that this was paid, right?
Paid for which month?
Well, I paid in full up until today, up until the day of judgment.
No.
They've not paid, Your Honor.
That's not what I'm contending.
Ho, the judge snaps back. That don't try to educate me line. That's courtroom code for you just hit a nerve. Judges don't like being lectured and especially not when the facts aren't on your side. Have you ever seen a judge go full make drop like this?
They're not paid in full. They've not paid. They're contending the value, the legitimacy of the default on the dates.
I'm Judge, if I may, and the court will allow me to explain, I'll tell you exactly what I'm saying.
Okay.
So there's issue substantively and there's issue procedurally. Substantively, they filed a complaint that says that rent was paid through March 31st. So obviously, that means that they're suing her for 1 month rent in April. She paid April because I attached the receipt. She gave me the receipt. I popped it into the it's on page 2 of the motion, and it shows that it was paid on April the 8th. So they gave her a 7-day notice on April 7th. She paid on April the 8th. Okay. Does she owe May? She probably does.
Probably.
But that's not what we're here about because they didn't give her a 7-day notice for May. They said she paid. They said she owes for April. That's problem number one. Problem two is that
When was the judgment entered, Mr. Smith?
Give me 1 second. I'll do this.
June 2nd, Judge.
Pardon?
June 2nd.
June 4th.
So your position, your position is that she paid the amount that was due in April, and that therefore what? They should have dismissed?
They sued her for April rent. She paid April rent.
I get it.
They don't have her 7-day notice for May. They didn't file a complaint for May. They want to file a brand new complaint for May and June. Great, you do it. But there was also an issue of notice because undisputedly they only gave you 6 days notice. She said she didn't get it at all. According to them, according to what's on file with the court, it was only done 6 days before the hearing. The court will say 7 days before the hearing.
Your Honor, just to point out, it says we didn't give her notice, but then on the other side of the argument says, well, in case you did, it was only given 6 days, which defeats the whole argument to begin with. And then proof of service itself, we cashed the actual filing with the post office, and there was a second service by the court. Both for May being a separate month, May being why we're here. Them admitting that probably they haven't paid May. They haven't paid anything.
Okay.
They argue motion for reconsideration on a default for non-payment. His argument is that it was a day too soon, which isn't true. The facts speak for itself.
Judge, if I may, because I didn't interrupt him. I said, they filed a complaint saying we owed for April. That's what we're here on. That's all this. They never filed a complaint for May. They've never filed a complaint for June. They've never given her a 7-day notice.
They don't have to.
Why don't they have to?
They do not have to do that. It depends on when the judgment was entered, and you just said June, right?
The judgment was entered on June the 4th.
Okay, June, right. So what are you suggesting? Are you saying that after she paid, listen to me, you want to talk? Are you saying that after she paid the April's rent, that the balance was zero, and that they should have dismissed this case and had to refile another 7-day notice? Is that what you're saying?
Here's the gut punch. The judge gets to the heart of it. Where's the defense if rent hasn't been paid? Notice how the whole room starts tensing up. Can technicalities really outweigh unpaid rent in court?
What I'm saying, if you listen to me, what I'm saying is that they never should have filed this case because they filed this case saying that April rent was due. She paid April rent. The only 7-day notice was in April that she received was an April 7-day notice. So you can't file a complaint for non-payment if you don't get a 7-day notice. Where's the 7-day notice for me?
Mr. Smith, did your client receive payment for April's rent before you filed the complaint? Yes or no?
Before we filed, no.
All right.
April the
Your
8th.
Honor, I don't want to interrupt you. Please, I'm sorry. I just want to point out, I think what we're saying is they admit they owe May, but they never got a 7-day in May. But we attached the 7-day to our response. We attached the post office date showing it was 7 days before the hearing. And we attached registered deeds at the court for the second mailing with the 7-day of the notice to the court. So I'm confused by this. I guess what it comes down to is really, I guess, arguing a motion to set aside default, which is good cause, which I'm assuming he's saying they didn't get started, which we have proof they did.
I know, but let me just read through this on my own here.
Sorry, Your Honor.
You're saying in paragraph 7, Mr. Sandweiss, client filed this lawsuit claiming that rent was paid through March 31, along with a 7-day notice dated May the 6th of 25, claiming that 1140 was due. If you guys can give me the dates,
Yeah,
I
I'm happy,
can
Your Honor.
sort this out. When was the first 7-day notice sent? When was the first 7-day notice sent? When was the complaint filed? Give me those, Mr. Smith.
I gotta look the exact dates up. The complaint's filed in March for the April. I don't want to be wrong, Your Honor. Give me a second. I apologize. If I could just say one thing that might help.
Go ahead, Mr. Smith.
Question, Judge, because he kept mentioning a reply or response to subject to motion. I have not received any response. I'm not sure what you're talking about.
Okay. I can't. I'm co-counsel. Your Honor, just one point.
Let's slow down. I'm going to ask Mike. Jennifer, when
Yes.
was this complaint filed?
The complaint was filed May 20th. I do show a demand for possession non-payment of rent that was mailed May 6th by Katie Spura.
All right, so if they sent that out on May the 6th, and you're almost, I think, acknowledged she didn't pay the May rent, what's the problem?
Because they didn't sue it for May rent, they sued it for the April rent. Complaint.
Originally sued for April. She paid most of April. There was an $85 balance for April. In May, we served a new 7-day because she had a balance and she didn't pay May. Then court just read the dates. We filed a complaint, had a hearing, got a default.
Where did it say all that in the complaint?
Boom. The judge just hit pause on this legal remix. The attorney's spinning a narrative, but none of it's in the actual filed complaint. If it's not on paper, it didn't happen. Always remember, in court, receipts or it didn't exist.
What are you talking about? We filed a complaint for April. The total amount, she didn't pay the total amount in her April. She left an $85 balance. We filed a new 7-day, which was attached and provided the court showing what she owed. Then we filed a complaint on the court rule on that 7-day notice. And that our service and the court service didn't appear. Got a default under, now you're here and you still haven't paid $1 on that.
Where does it say all these things that you're telling me now? I'm looking at the complaint. The complaint says rent is paid through March 31st.
The detailed response that was served on you in the court.
When was this response filed?
Your Honor, it was filed and we received it on the 20th.
There you go, Mr. Sandweiss.
Well, let me double check. I do not have any M-file response. I'm double checking it. So the last thing that I have on the MI file was the notice to appear that was sent by the court on the 17th.
Counsel, why wasn't your client here?
They still live there.
Because my client never received it, and she received the judgment and she received the notice to appear at the same time. So, and I looked at the dates on the notice. The notice wasn't proper because the notice was sent from the court 6 days before the hearing, and the court will require 7 days. And that I'm saying she said she never got it, and I'm saying even according to what he filed, it only was 6 days. Even if let's assume that he's right. They mailed it. Okay. I don't have to tell you there was a mail like these days, but it still says, according to their record, it was only sent 6 days before. That's not sufficient service under the rule.
This is the Hail Mary. Defense is begging the judge to restart the whole case. But unless they can show a solid defense and a good reason for missing court, it's like trying to undo a checkmate after you've already lost the queen.
Mr.
All I'm saying is, set aside the default, reschedule the hearing. If you want to have a hearing, that's fine. Reset it, set it for the next week. That's fine. We'll deal with it. But
I have to find two things: good cause and the meritorious defense. Where's the meritorious defense? She hasn't paid for May. You agree with that, right?
That's what he says. I don't know if she paid for May or not.
Where is she?
It's for April. She paid April.
Where is she?
What's that?
Where is she?
She's at work.
No. You indicated all but, I think, in the beginning here, that she didn't pay for May.
I think that's correct, but I'm not going to swear to that, but I can't say for sure. I think that is correct. They didn't sue for May; they sued for April, and she did pay April. If they want to sue for May, then they'll let them amend their complaint. That's fine, but they're not entitled to a judgment for something that she didn't have notice of before the time. That's what I'm saying. There's a due process issue here. You can't just come in and say, well, my complaint says one thing, my 7-day notice is another thing, and I'm asking for judgment for a third thing.
Ho, the judge snaps back. That don't try to educate me line. That's courtroom code for you just hit a nerve. Judges don't like being lectured, and especially not when the facts aren't on your side. Have you ever seen a judge go full Mick drop like this?
That's not the way this works.
I've been doing landlord tenant cases for 30 years. Don't try to educate me. She had a balance of $85. It went to a hearing. She didn't show up. We sent the judgment out to her. She didn't pay the balance. She didn't pay the balance that was owing for April. She had $85 that was still due and owing. Then she didn't pay for May. It's not incumbent upon them to drag a affidavit out of your client. Your client should have said, I paid for May. I paid for June. This judgment is void. How much did I say that the late fees exceeded? And I trust that was all accidental. Correct, Mr. Smith?
Yes, it was only May. It was $15 too
much. I just want to make sure that you always only ask me for $70 a month if that's what the contract says.
We know that very well. That was a mistake on our part. We apologize.
That's fine. Mistakes are made. I wanted her here more to talk about this because I thought that he was contesting what the balance was. And the fact is, she still hasn't paid. I'm going to deny your motion for reconsideration and or to set aside the default judgment. I will do this. You're going to do an amended judgment backing out the late fees. You're going to submit it to me. And I'm going to make the writ date July the 3rd. So the writ date will be July the 3rd. That shouldn't include any more rent here, right?
Correct.
So you're just going to back out the $10 or $15 in amended judgment. Your finance to pay up. And that total amount then will be what, Mr. Smith?
Here, give me a second. I'll say trying to find the actual judgment, so I say correct and apologize.
I don't have the judgment in this packet here.
I don't have the judgment. I have the amount. I want to make sure it's correct. I don't want to say it wrong, but we will take out the $15 when we file it. My understanding was $2,265 for rental charges and $176.54 court cost. That was $15 too much for May's late fee, which we'll deduct and refile.
So you're going to so it's going to be $161.54 then, right?
Yeah, let me just.
So It should be 242654. That's my.
Give me a second.
Yep.
Trying to call them.
Take your time.
So the number I have is $2,441.54 minus 15 comes to
426.
26.54. Yeah, correct.
Submitted an amended judgment this morning.
And that judgment said to you that was paid by July 1st, or they considered it?
Correct. Actually, I could easily order out now, to be honest with you. But I'm not going to do that. So I'll give her those extra days to come up with the money. Okay? Thank you. Thanks.
Judge, could I just ask Mr. Smith, or ask the court to ask Mr. Smith, to forward me a copy of whatever he tells me that I have it, because I am not